If you're a legacy songwriter or producer, here's a topic you should know. U.S. copyright law may give you the right to recapture the copyright in the song you created, despite the bad agreement you signed back in the day. It's a legal concept called a termination right and is part of U.S. copyright law. The basic idea is simple. Early in your career, you might have signed a deal with a publisher or production company when you had very little leverage, so it was not in your favor. Years later, that work may be more valuable than the original deal reflected. So Congress built a legal reset button into the Copyright Act so authors can potentially terminate that original deal and recapture the rights. If you qualify, this is a federal right that generally can't be waived in advance by contract, even if your contract says the rights were assigned forever or for the life of copyright. In general, there are 6 steps to the copyright termination process. First, you should confirm whether you qualify. Termination usually applies when the rights were granted by the author, not a transfer of rights by someone else. Also, the right does not exist for a songwriter who is working as a work made for hire for a company. In that scenario, the company is considered the author. Second, you must identify your timing window. For many works created after January 1st, 1978, termination can be done during a 5-year window that generally starts 35 years after the grant was signed or sometimes when the song was released, which is called the publication date. Timing is everything. Next, you must pick an effective termination date that falls inside your timing window. This is the date the rights will revert back to you, as long as it falls within the allowed window. Fourth, you will prepare and serve the notice of termination. The law requires a formal written notice with specific information, like the work, the original grant, the parties, and the effective termination date. That notice must be served on the current rights holder no less than 2 years and no more than 10 years before the effective termination date. Fifth, record your notice with the U.S. Copyright Office. To be effective, the notice must be recorded before the termination date. The last step is to handle all necessary business after the rights revert back to you. Once this happens, you will need to correspond with the grantor and update ownership and royalty information with your performing rights organization, such as ASCAP or BMI, your mechanical licensing organization, such as the MLC, and the record label that owns the recordings of the song. You will then have the right to relicense the rights, renegotiate, or move to a new partner in connection with new deals. It is worth noting that this is a U.S.-only right. You will not recapture international rights to your song. Also, you will not recapture rights to deals that existed prior to the termination date, such as agreements for a remake or sampling of your song in a recording. This right is powerful, but it's technical and deadline-driven. So the smartest move is to consult with an experienced copyright attorney to help you navigate the process.